Good afternoon, everyone. Thank you very much for joining us for our webinar today, Trust in Your Will. I'm very pleased to welcome you. I am Stewart Stretton-Hill. I am a Senior Associate in the Wills and Trusts team with Owen Mitchell, and I'm delighted to be joined by my excellent colleague Louisa Chadwick from our Deputyship team. My job really is to specialise in helping families to plan for and to protect assets for beneficiaries who may lack or may in the future lack mental capacity to manage their own property and financial affairs. Louisa very much focuses on managing property and financial affairs for individuals who already lack their mental capacity, and between us I hope we'll be able to answer all of your questions today. And what I'm going to do today is explain really what happens when your child reaches 18 and they are unable to manage their finances, and what you can do for them through your will, through trusts, to help protect your assets for your child as best as possible. I expect the webinar will last about an hour, and there's opportunity to ask questions all the way through. Please do submit your questions using the Q&A function, which you should see on your screen. Just click on that and please submit your question. When sending your question in, please do include your name and email address, so if we're unable to get onto your question during the course of the webinar, we will respond to you directly after the event. We're also recording this virtual event, and it will be sent out afterwards via social media, and towards the end of the session there'll be a feedback link posted on the screen. I'd be really grateful if you would just take a couple of minutes to let us have your feedback on this presentation. We've had a number of questions submitted in advance, so thank you very much for those. I say quite a number, a lot have come through, so it seems this will be a very popular topic, and say most of those questions will be covered by today's content anyway. There are some that I will specifically address as we go through, and actually on that note, one of the questions that was asked is to which country this legal advice in this presentation is relevant, and basically it's England and Wales. If you have assets in other countries that you would like to protect for children, then absolutely you should be taking advice from a solicitor in the jurisdiction where that asset is based. That said, we have an international tax advice team who are based in our London and Newbury offices, who also are very happy to liaise with lawyers overseas to best structure assets to protect individuals. Another question we've been asked as well is wanting information around powers of attorney. I'm not going to be majoring on powers of attorney today. This is very much going to be focusing on using wills and trusts to protect assets. I will be talking about deputyship. I will touch on powers of attorney, but so if you do have any questions specifically related to that, do feel free to submit details through the Q&A. If we don't answer them today, we'll be very happy to answer them after the event. So the starting point really is what happens when a child reaches 18 but they lack capacity to manage their finances. The first thing you need to understand is that legal capacity is decision specific. So it means someone might have capacity to, say, pay a gas bill or pay utility bills, but they may not have the legal capacity to be able to decide to sell a house. They might have legal capacity to make a power of attorney, and if so, what they can do through a power of attorney is to appoint someone else to take financial or health decisions on their behalf. But if they don't have capacity to manage some or all of their finances, and they don't have capacity to make a power of attorney, then it's going to be necessary for someone to apply to the Court of Protection to be appointed as their deputy. And I say someone, it could be anyone who applies to the court to be their financial deputy. The role of a financial deputy is to manage and take decisions about assets that are owned personally by the individual who lacks capacity, and I must emphasise that word personally, because that is very relevant when we come to talk about trusts later on. The authority of the deputy comes from the court order, and the court order itself might be quite restrictive in terms of what the deputy can do. It's quite bureaucratic as well. A deputy must purchase an insurance bond. If they do something wrong or make a mistake acting as deputy, which causes loss to the individual's estate, then that insurance bond should pay out to cover that loss. Applying to be a deputy is a long process. It commonly takes at least 6 months. I'm sure Louisa may say it takes even longer through her experience in the Court of Protection. I can see her nodding on my screen there. So it is a long process applying to be a deputy, and it's quite bureaucratic. One of the questions we had asked before this presentation was what happens for a child accessing a child trust fund or junior ISA after they turn 18 but they have learning difficulties. Well, as I mentioned earlier, if they're judged to have mental capacity to be able to access and manage those funds, they can do it personally. If they don't have the requisite mental capacity and can't appoint an attorney, then someone will need to apply to be their deputy to manage those funds on their behalf. So the court-appointed individual, the deputy, is the individual who will manage the individual's bank accounts, pay bills, purchase or sell a property, sign contracts and leases, later on maybe claim pensions, maybe claim benefits on behalf of the individual, possibly make care arrangements as well if that's what they need. The deputy is supervised by the Office of the Public Guardian and the Court of Protection, and they've got to produce accounts annually to the OPG and to report to the OPG on their actions each year. The Court of Protection is also required, authority may be required from the Court of Protection for the deputy to take certain decisions, such as whether to buy a property or making a will for the individual who lacks capacity, or maybe making gifts on their behalf. And because deputyship is so bureaucratic, it's something people often want to avoid, and that's with great respect to my colleague Louisa, who does a wonderful job in managing deputyships. It is very, very bureaucratic and can take a very long time even to do quite simple things. So beware, if you leave assets outright to your child under your will or under intestacy, that's what happens if you don't have a will, and they're unable to manage those assets themselves, a deputy will be needed. So a potential solution to this is to set up a trust in your will. And a trust is a very useful way of keeping control of assets within the family. Basically, you'd leave assets, instead of leaving assets outright to your child, you'd leave them to the trust in your will. Because those assets wouldn't be owned personally by your child, a deputy is not required to manage them. There won't be a need to report to the Office of the Public Guardian. You get to decide who the trustees are, who are the people managing those assets for your child. And it can be very flexible without needing to involve the Court of Protection. Trustees of a will trust, for example, may be able to make gifts on behalf of your child. That's something that would require the court's approval if a deputy were appointed instead. So let's have a little bit more of a look at wills in detail. I hope everyone on this call appreciates that wills are a very, very important thing to have. Ideally, everyone should have one. I often say that wills are your final word in this world. There was a statistic I heard some time ago from comedian Will Ferrell. He said 98% of people at some point will die in their lifetimes. Personally, I think that statistic is slightly higher, and it does surprise me that not everyone has a will. Wills are very important for a variety of reasons. Authority. There is someone appointed to look after your estate after you die. You get to choose who your executors are, who are the people who can have that authority. There's certainty by having a will. You know exactly who's getting what and when. It's flexible, as I touched on earlier. If you've got a will trust in place, it can make much easier planning for your child in the future, managing assets for them much easier. If you don't have a will, intestacy will kick in, and I'll talk a little bit about what that means later on. And the question about whether you should do your will yourself. It is certainly possible to do your will yourself, but in a situation where you have a child who may lack mental capacity to manage the finances after you've gone, you're going to want to make sure it is done right, and will trusts can be very complicated. And we had a question raised before the session asking who looks after our children's interests, both in terms of care and finance, after we've gone. The individual who posed the question said they don't have family who can do this. By making a will, you can appoint the trustees of the will trust to look after your child's finances, to make sure those assets are best used for their interests in the future. In terms of looking after their care and health decisions, yes, the trustees will have some control over the care that is purchased, but they won't have control over the individual's actual medical and care decisions. That would have to be taken by the treating doctors or local authority, or if someone's successful in applying, a health and welfare deputy. I'm not going to talk much about health and welfare deputies today, but just to say that it's quite difficult to be appointed as a health and welfare deputy. The court is quite reluctant in appointing health and welfare deputies, and the reasons for this is that anyone acting for an individual in relation to their care or medical treatment must already act in that individual's best interests. So the court is quite reluctant to appoint a deputy, a health deputy, over and above the individuals already taking those decisions. One thing I should emphasise, though, is that a health deputy is quite separate from a financial deputy. You can be a financial and or health deputy. So let's look at some of the importance of wills in a bit more detail. I mentioned authority. The authority of an executor comes from the will itself. As soon as the individual has died, executors can start arranging the funeral, they can start distributing personal belongings, you can start corresponding with the banks and possibly even withdrawing money from the banks, although technically accounts should be frozen until a grant of probate is issued. An executor can also put a house on the market straight away after death. The house can't be sold until a grant of probate is issued, but at least they can start doing the basics straight off. You can also, under your will, appoint guardians for children who are under 18, and this is coming back to the question that was raised earlier. If you die while your child is under 18, guardians appointed under your will can take those decisions that would normally be taken by the parents. So they could take decisions about schooling, about medical and care treatment as well. So a will from that point of view, from granting authority for people to look after finances, from granting authority for people to take decisions about children who are under the age of 18, is very, very important. I mentioned certainty as well. If you make a will, you know exactly who's dealing with the distribution of your estate. It's going to be your executors. You know who's going to be dealing with your funeral wishes. Again, your executors will be taking those decisions for you. You know who's going to be looking after your minor children. It's the guardians. Wills are an excellent way of making sure there are no surprises for those who are left over. It's a very good idea to talk about your will in advance with your family, particularly if you're thinking of treating family members unequally. And that may be very relevant where you have a child who has learning difficulties, who has extra needs. You might be thinking, actually, I'm going to need to leave them more of my estate as against children who don't have those needs. Make sure that your children are aware of this. It will help to avoid disputes in the future. And although they are difficult conversations to have, no one likes to talk about death and what should happen after you've gone. It is much easier to have that conversation when you're alive. It really is. I touched on flexibility as well. I'm going to be talking in a lot more detail about will trusts shortly, but importantly, a will doesn't need to be set in stone. People often think wills are these things that are written by monks in illustrated manuscript and you can't touch them, they can't be changed, and that's it, it's there, the beneficiaries are getting what is set under the will. But actually you can make it very, very flexible by using a trust structure. If you put what we'd call a discretionary trust in your will, none of the beneficiaries you list are technically entitled to anything except what the trustees, the executors, choose to give to them. And I'll talk about this in more detail, how that works in practical terms later on. But this is a really useful way of protecting family assets from remarriage of a beneficiary or a surviving spouse, from future divorce of a beneficiary. If a beneficiary is declared bankrupt, those assets in the will trust may not need to be taken into account in the bankruptcy. And particularly where you've got a vulnerable child or a child lacking mental capacity, Will trusts are a really useful way to protect that child from influence of a third party, from their own mental incapacity or their own spendthriftness. If they are someone who likes gambling or spending too much money on eBay, the trustees can control the amount of money they are due to receive from the trust during their lifetime. And trusts are quite a useful way to reduce the inheritance tax charge on an estate as well. Again, I don't want to dive too much into tax in this presentation. That is a presentation of its own that could last many hours, but suffice to say that the basic rules for inheritance tax is that it's charged at 40% on the value of an individual's estate that exceeds £325,000, where those funds are left to anyone other than a spouse or charity. Recently, I say recently, over the last 4 years, an additional allowance called the residence nil rate band has been introduced, which is an additional allowance of £175,000 that is available in certain circumstances. You need to make sure your will leaves assets correctly to children or to trust children's benefit in order to claim that residence nil rate band. But basically, by properly structuring your will, a couple, husband and wife or civil partners, can leave up to £1 million tax-free down to their children through either outright or through a trust structure. And again, one of the great advantages of trusts in wills is they can adapt to the circumstances of the beneficiaries at death as well. I'm going to talk more about that as we go on. So what happens if you don't have a will? Well, essentially, you haven't got any authority, it's really uncertain, and there's no flexibility. If you don't have a will, you are what is called, or estate is what is called intestate. And that means that before anyone can start closing bank accounts, can start marketing the property, they need to apply for a grant of administration. That's the equivalent of a grant of probate, but is issued where there isn't a will. Anyone who takes any action before getting a grant of administration is personally liable for the steps they take. So, for example, if you started arranging the funeral, but weren't the person who's entitled to take out the grant of administration, you may find yourself personally liable for those funeral costs with no right of recovery against the estate. It's uncertain. Distribution of the estate is governed by statute, and unless you know in detail what the statute says, you may not appreciate where your assets go. And not all assets will necessarily automatically pass to a spouse. There are certain assets that pass outside of the estate that won't be governed by intestacy. Really importantly, who's going to be looking after assets for a disabled child? Under the intestacy rules, children inherit at the age of 18, no questions asked. And this leaves the child at risk of needing a deputy, if they haven't got capacity to manage the assets themselves, or at risk of influence from third parties. And there's no flexibility. If assets under intestacy pass outright to an individual who's getting divorced or has been declared bankrupt, those assets are available to settle that divorce or to settle that bankruptcy. If the beneficiary is in receipt of means-tested estate benefits and they suddenly receive a large inheritance under intestacy, well, not even a large inheritance, really anything over £6,000, they will lose entitlement to those state benefits. I touched on the point that minor children inherit at the age of 18. Even children without learning difficulties will not necessarily have very sensible ideas on what to spend money at the age of 18. And potentially you might suffer unnecessary inheritance tax. So it's very, very important to have a will, even if you think your estate is straightforward. So how do trusts under wills work? To deal with that, we'll look briefly at what a trust actually is. And they have been around for centuries. They go right the way back to the Crusades. And don't worry, I'm not going to be going through a long history lesson explaining trusts in huge amounts of detail. But the basic concept is a trust is a split between the legal ownership of the asset and its beneficial ownership. And what I mean by that is really who is the individual who is entitled to deal with the asset. They have the legal ownership, compared to the person who's entitled to receive the benefit. They have the beneficial ownership. A very, very simple example is something like a nominee bank account that you may well have for your children already, where your name is on the account. You are the person who can give the instructions to the bank as to whether to pay money in or pay money out or close the account. But the underlying money belongs to your child. At the age of 18, they can turn around to you and say, right, hand it over. But until they reach that age, you are the legal owner, the trustee, and they are the beneficiary. So where you have a trust under your will, it's exactly the same relationship. Normally, the executors of your will become the trustees, although you don't need to have the same people as executors as trustees. But the trustees will deal with selling or renting out a trust property. They are responsible for dealing with the upkeep of that property and using the trust funds to maintain the property. But very, very importantly, trustees are accountable to beneficiaries for their actions. So this means if a trustee decides that they're going to run off with the money, then they are acting in what we call breach of trust, and beneficiaries have the right to pursue a trustee for any loss to the trust fund. A trustee is personally liable for any loss that they cause to the trust fund through their own negligence or fraud. And trustees must keep accounts. Now, I mentioned it's easier than being a deputy, more flexible than being a deputy. It certainly is. Although you must still keep accounts as a trustee, you don't need to provide those accounts to the Court of Protection. You must, however, provide them to the beneficiary on request. The underlying beneficiaries, those entitled to the fund, are able to call on the trustees to account for their actions. They're entitled to see a copy of the trustee to know what their interest is. And ultimately, they are entitled to the value in the trust fund in some way. And I say in some way because there's all sorts of different types of interest that you can have in a trust. And you may have heard of all sorts of different terms about trust: will trust, pilot trust, disabled persons interest trust, asset protection trust, all these sorts of things. They're all different terms to describe different types of trust interest. At the root of it, there are only three types of interest a beneficiary can have under a trust. The first type is a bare trust, and that's where the beneficiary is absolutely entitled to the trust assets. That's that relationship I talked about earlier, the nominee bank account relationship. The idea there is the beneficiary is absolutely entitled outright to the money in the account. So at any point, they can turn around to the trustee and say, you have to give that money to me, it is mine. And the bank account would have to be transferred into the individual's name. So taking the example of the child's bank account, I've got bank accounts in my name for my two children, and at the age of 18 they can turn around to me and say, hand that money over to me, and there's nothing I can do about it. It is their money. The second type of interest is a life interest. Under that type of trust interest, a beneficiary called the life tenant is only entitled to the income from the trust fund, whatever that might be. So the trust might own, say, a property or some investments or a bank account. Any interest generated by the account, any dividends generated by the stocks and shares, and any rental income generated by the property are paid to the life tenant. The capital beneficiaries are known as the remainder beneficiaries, remaindermen, and they become entitled to the capital of the trust fund at some specified point in the future. The normal way this would work is the life tenant would receive income from the trust for the rest of their life, and then on their death, the capital would pass to the remaindermen. A classic example of this is under someone's will. You would say leave a life interest to your spouse. They'd be entitled to live in the matrimonial home. They'd be entitled to interest and income from the bank accounts. But immediately on their death, or if the will said so, on their remarriage, the capital passes outright to the children under your will. So it's a very useful way to help protect assets from a remarriage or possible disinheritance to another family in the future. And the final type of interest is what we call a discretionary interest. And in that you have a list of beneficiaries, none of whom have any entitlement to the trust property, despite what the trustees decide to give to them. So at no point can any discretionary beneficiary turn around to a trustee and say, you must hand the income or the capital of the trust to me. It's totally up to the trustees to decide what, if anything, to give to those beneficiaries. And there was a question that was posed before the session, asking, can you delay inheritance until your children are much older, as they may potentially be unable to manage money due to educational needs? Simply, you can, yes. You can use a discretionary structure to say the beneficiary is not entitled to anything until the trustees decide they are able to manage the money, or until the trustees decide to purchase something on their behalf. Another question we had earlier is how to make a will to protect an autistic son while being fair to your other 3 children. And the answer there is to mix and match. So you could divide the estate into 4, have one share of the estate going into a discretionary trust for the benefit of the autistic son. He wouldn't own the assets outright, the trustees could manage it for him, and the other 3/4 going outright to your other 3 children. So trusts are a very useful way of protecting assets for children in the future. I mentioned the life interest and the discretionary interest. Under those types of interest, the beneficiaries don't have any right to capital, which means if they are on means-tested state benefits, the value of the trust fund should not be taken into account when it comes to claiming those benefits. If they're going through a bankruptcy or divorce, the value of the trust fund shouldn't be taken into account. Now, I say shouldn't. The divorce courts are quite good at looking behind trusts and looking behind the purpose of trusts. And if in reality a discretionary trust has only ever really been used for the benefit of that individual, it is possible for the divorce courts to look behind it and to have the value of the trust taken into account on a separation or divorce. That said, it does at least add a layer of protection, and a well-worded will, a well-worded letter of wishes going alongside the will can really help to protect assets from those future claims. Control of the trust assets is very important as well. The beneficiary does not have direct control over the assets. It's the trustees who are looking after it, which means that if a beneficiary lacks capacity, if they are a spendthrift, if they do have a third party sniffing around, the trustees can drip feed the funds to the beneficiary. They can keep control of that capital and not hand it over to potentially be lost on frivolous purchases or a dubious boyfriend or girlfriend who's got their hooks into them. Trusts are a great way to protect assets for the future. I touched on state benefits, but also care home fees as well. It's a hot topic of conversation at the moment. Care homes are going through a lot of financial difficulty, both before and even more during this COVID crisis. By leaving assets into a trust and not leaving them outright to a surviving spouse who may need care in the future, those assets held in the trust shouldn't be taken into account when it comes to claiming state aid to pay for care home fees. The flexibility I've mentioned as well. One of the great advantages of the discretionary trust, and I'll illustrate this a bit later, but where you do have children with different needs, different successes in life, you may think, actually, I don't want to split my estate equally, or I want to drip feed money to them. By leaving assets in a discretionary trust, the executors decide how much to give to those beneficiaries and when. Leave a letter of wishes with your will that says to your trustees, look, I have a child who has learning difficulties, they need extra support. I would like you to provide funds to assist them in the future. I would like you to benefit them more than my other children. The letter of wishes is not binding on the executors, which means they can respond to the beneficiary's needs. So if one of the able-bodied children falls ill or is declared bankrupt or falls on hard financial times, the trustees can benefit them more from the trust fund in the future and even out the interests under the trust. And an underlying point that I've mentioned all the way through this, a deputy is not required to manage the trust assets because they do not belong personally to the mentally incapable beneficiary. Again, a question we received prior to this session is how to protect my home for my severely learning disabled daughter when I die, ensuring she's not forced into an ATU. The answer is there, using a will trust. By leaving the property on a life interest for your daughter, it means it's available there for her to live in, but the capital value does not belong to her. The trustees could sell that property and buy her another one that is more suited to her needs in the future maybe, but at least she has the right to remain in that property for the rest of her life. So some great advantages to trusts. There are some disadvantages, of course. Trusts must be administered properly. The trustees need to know what they are doing. They've got to complete tax returns each year. They've got to prepare accounts and report to the beneficiaries. If you have a discretionary trust in particular that's not managed very well and funds are just paid outright to a beneficiary, it is possible for third parties to challenge the true meaning behind the trust and treat those assets as belonging outright or the income belonging outright to the beneficiary. So it's very important they're administered properly. Obviously, it's very sensible to get legal and accountancy advice in dealing with the administration of the trust. Trustees must comply with their obligations under the trust. They've got to have a statement of investment, how they're going to invest the trust fund. They've got to think about the beneficiary's different interests. They've got to invest the money properly, or invest the funds properly, to account for the interests both of the capital beneficiaries excuse me, and the income beneficiaries as well. They've got to have meetings. Now, these meetings can be virtual, they can be over the phone, they can be by email, but it's very important that trustees do liaise with each other and note what they are deciding to do with that trust. They can make minutes, they can prepare documentation recording what is happening with the trust, and that is vital. If the revenue of a third party challenges the trust in the future, you've got to have a document trail showing what is being done and why it's being done. There's also potential conflict of interest. There is no difficulty, no legal requirement to prevent the trustees also being beneficiaries of a will trust. For example, as say the surviving spouse example, the spouse could both be a trustee and a beneficiary, but it might place them in conflict. If they're administering the trust for their own benefit, they've got to be thinking very carefully about how they are treating their own interests compared to that of the other beneficiaries. And as a result, there's always going to be a cost factor there. The cost of legal advice, the cost of accounting advice, all the way through the trust, the lifetime of the trust. It's not possible to give an estimate of what that will cost because it will very much depend on the structure of the trust. It will very much depend on the needs of the beneficiaries and what decisions are being taken during the lifetime of the trust itself. I don't want to talk too much about tax, except to say that unfortunately the government doesn't really like trusts when it comes to tax. Trusts themselves, discretionary trusts, are taxed at 45% income tax. Any income earned by a discretionary trust is taxed at 45%. When it comes to capital gains tax, so that's the tax you pay on any increase in value between an asset when it's acquired by the trust and the asset when it's sold by the trust or given outright to a beneficiary, then you only have half the annual allowance and you're potentially paying capital gains tax at either 20 or 28% tax rate. But where you have a vulnerable beneficiary, that is a beneficiary who may be mentally incapable or is in receipt of certain benefits, the trustees can either create a life interest, that right for the beneficiaries to receive the income outright, or they can make what's called a vulnerable beneficiary election. And if they do that, the trust is essentially taxed as if the beneficiary owned those assets outright. So they'll have their own income tax rate applied, and they'll have their own capital gains tax allowance and capital gains tax rate applied. So although trusts do technically suffer a higher tax rate, where a disabled beneficiary is involved, you can reduce that tax rate to a standard and personal rate. When it comes to inheritance tax, everyone thinks, or many people think, that inheritance tax only hits on death, and that's not the case when it comes to trusts. Discretionary trusts under a will or trusts set up during your lifetime suffer tax up to 6% when assets leave the trust and every 10 years. So it's worth bearing that in mind and budgeting that when deciding whether to set up a trust. But once again, legislation comes to the rescue. If you have a disabled person as the beneficiary of that trust and structure the trust correctly, then you can claim that it is a disabled person's interest trust, and the underlying trust assets for tax purposes only are treated as belonging to that individual, which means they're not taxed until the individual dies. They don't suffer inheritance tax until the individual dies. So, for example, if I decided to leave my house on a disabled person's interest trust to my child, it would suffer inheritance tax on my death, but then it would not be taxed again until my child dies. But the value of the property would not be taken into account for divorce, remarriage and benefits and all those reasons I talked about earlier. When it comes to administering trusts, I've mentioned this before, do it properly. You've got to make sure that the trust document or the will gives sufficient powers to your trustees. I deal with a lot of very old trust documents that go back to sort of 1920s, and back then trusts were sort of a slightly different beast, and trustees people setting up trusts weren't necessarily thinking about what powers the trustees might need in the future. And often it's necessary with older trusts is to go to court and get the court to either give the trustees additional powers or to make decisions about how the trust should be run properly. So it's very important to set up a trust properly in the first place. Get legal advice on it. Make sure it's going to be as future-proof as possible. Make sure the trustees exercise their powers properly. It's not necessarily just going to be a case of thinking, well, the beneficiary needs a car, the trustees will buy it and give it to them. They should document their decision. It may be an additional deed is required to move money from the trust to the beneficiary outright. Trustees have their duties. They've got their duties to report to the revenue. They've got their duties to report to the beneficiary themselves. They must comply with those duties properly. They've got to document their decisions. I've touched on that earlier. They've got to do their tax reporting. A trust is essentially just like an individual. They've got to do an annual tax return and report that to the revenue. And there's some hefty fines for trustees if they fail to report the trust tax position to the revenue each year. And they've got to keep accounts. Everything I've said so far has really related to will trusts, but actually there's no reason why all these comments I've mentioned couldn't relate to setting up a trust in your lifetime as well. So I've mentioned the idea of parents leaving assets to children under their trust, but what about other family members? If their wills leave assets outright to your child, then you're back in the same position. A deputy is going to be needed to manage those assets. Instead, maybe the family member could leave the assets to you under their will, or maybe they could make the gift to you. The problem there is it's going to increase the value of your estate, and that might cause an inheritance tax issue for you, or it might affect your benefits position if you're in receipt of benefits. Instead, what you can do is set up a trust in your lifetime. It could be life interest, it could be discretion, it could be any one of the type of the trusts we've talked about earlier. And that trust just holds £10. You could be the trustee of that trust, but it's ready then, sitting there to receive income, to receive funds from other sources. And those other sources could be a grandparent wanting to make a gift to your child, but not wanting to give them the assets outright and mess up their benefits position. It could be from a pension payout. It could be from death in service payment in your employment. It could be life insurance. Instead of directing that those assets, those payments should be made direct to your child or direct to you, you can ask for them instead to be paid into the trust that you've set up during your lifetime. No reason why you couldn't be a trustee of that trust, managing those assets for your children. After you die, the continuing trustees, whoever you've appointed as trustees during the lifetime, will carry on managing those assets for your child. And I should say a trust will not die just because a trustee dies. A trust will carry on until it's depleted of assets. This is a useful way, again, the lifetime trust is also a useful way of avoiding the need for a deputyship. It avoids third parties leaving assets to your child, which might accidentally need a deputy to start managing those assets. One of the questions we had before the session again was, as grandparents of a disabled grandson, we're interested in knowing what support we can provide most effectively during our lifetimes, and more particularly in our wills. Well, the answer's there really. If you want to give support during the lifetime, don't give assets outright to the disabled grandson. Set up a trust for their benefit. Put the assets in that trust. They can be managed for them, drip fed to them. They can be used to purchase assets that the beneficiary, the grandchild, could use without affecting their own benefits position. Hopefully that's given a fairly whistle-stop, fairly quick overview of will trusts and trusts, but I just wanted to highlight how this can work in real life with a case study. So we've got Mr. and Mrs. Scratchett here. Mr. Scratchett was widowed previously. They've got a property and some savings. Their whole estate between them is worth about £1.2 million. They've got 3 children, Tom, who's 16, Bob, who's 21, and Alice, who's 25. Tom is in full-time education and unfortunately has special educational needs. Bob very sadly suffered a brain injury as a child, and he's mentally incapable of managing his finances. He doesn't have a deputy appointed for him. Alice, on the other hand, has been very successful and runs her own business. So this is what Mr. and Mrs. Scratchett do when they don't get it right. They don't make wills. On their deaths, jointly, assuming they both die together or die within short succession of each other, their estates are liable to £80,000 of inheritance tax. In other words, that's the £200,000 over the £1 million limit I mentioned earlier, is taxed at 40%. The rest of their estate passes equally outright to their 3 children. So each of the 3 children get about £370,000 each. So let's have a look at what happens for each child. So poor Tom, he's actually not too bad in terms of managing his finances, and at age 18 he is living independently, and he's managing his own finances. He receives his £370,000, but he's still young, doesn't see the need to own a property, and he's preferring to rent with his university friends. Unfortunately, because of his learning difficulties, he is easily influenced and he's vulnerable to financial abuse. He meets a lovely young girlfriend and they rent a property together, but unfortunately she starts persuading him to buy her expensive gifts. The money he's been left under the intestacy from Mr. and Mrs. Cratchit runs out, and Tom has to move into state-funded accommodation. He loses all faith in relationships and ends up as a sad and lonely bachelor. What happens to Bob? Well, Bob does need full-time care, but his health needs aren't sufficient to qualify him for what's called CHC, continuing healthcare funding, and that's where the NHS would step in and fund Bob's care needs out of their own pocket. Instead, he's having to rely on state-funded care. Unfortunately, he's received £370,000 under the intestacy. He owns more than the local authority state limit of £23,250, so the local authority won't provide any financial assistance towards his care costs. He will also lose all means-tested benefits. He's unable to manage his own finances. Alice is too busy to do it for him. She's very busy and tied up with her business, so she's unable to act as his property and financial affairs deputy. Instead, the local authorities step up and apply to be his deputy. Unfortunately, relatively swiftly because of his care costs, Bob's inheritance runs out, paying for his care, and he's reliant on the local authority to meet his care needs. And they're also managing what little finance he's got coming in. Finally, we've got Alice. Well, she uses her money to pay off her mortgage and invest in the balance in her business. Before her parents died, though, Alice did take some time off looking after them, and as a result, her business had suffered, and she has to use the inheritance to prop it up. The business ultimately fails, and she has to file for bankruptcy. All the money she was received under the will, under the intestacy, is assessed in that bankruptcy. She's forced to sell her property and the business and to settle the business debts, and has little money left, so seeks employment elsewhere. So that's a bit of a disaster story for poor Tom, Alice and Bob. So what happens if Mr. and Mrs. Cratchit did it the right way? So this time they do make wills, and they leave everything into a discretionary trust. And by way of reminder, the discretionary trust is where the executors of the estate decide what, if anything, Alice, Tom and Bob will receive from the will. The trust structure enables Mr. Cratchit to use his former late wife's nil rate band. That means he can actually, between Mr. and Mrs. Cratchit, they can actually benefit from a nil rate allowance of £1.325 million, £1,325,000. So there's no inheritance tax to pay on their estates whatsoever. They appoint Alice as one of the trustees, together with a professional trustee, and Owen Mitchell acts as professional trustee on a number of estates. And they leave a letter of wishes with their will. And I mentioned earlier, the letter of the wishes is a document that gives guidance to the trustees as to what Mr. and Mrs. Cratchit would like to happen to their estate. And the letter of wishes says that they'd like a third of the trust fund to be kept in the trust and not given to Tom until he's financially mature. 1/3 of the fund they would like to be kept in the trust and used to help with Bob's care needs. And the final third of the fund should be given outright to Alice if she wants it. So how do things change? Well, happily ever after Tom. As I mentioned, his condition's not too bad, and by age 18 he is living independently and is managing his own finances. He still doesn't want to own a property, and he's preferring to rent with his friends, but his share of the trust is now invested to give him an income to help pay the rent. He meets the same girlfriend and she tries to pressure him into buying these nice gifts, but the trustees spot what she's up to and limit his access to the capital funds, giving him income only. She sees that Tom isn't the goldmine that she hoped that he would be, and she eventually leaves him, but fortunately Tom meets a lovely girl, Wendy, who helps him manage his finances properly. The trustees are satisfied that he's now financially mature, and they see he's got married and he's settled down with a nice young lady. So now that the trust fund is not at risk, they give the share of the fund to him outright, and he uses it to buy a property and live happily ever after with Wendy. What about Bob? Well, Bob still requires full-time care, and he still won't receive CHC funding. This time, though, he does not personally own more than the £23,250,000 limit set by the local authority, so they step in to help fund his care costs. He doesn't need a deputy to manage his funds because the trustees are managing those funds in the trust itself. The trustees can use those trust funds, and they buy a property specially adapted for him, and he's able to live in a comfortable property with care provided by the local authority and additional care topped up from the funds available in the trust. On Bob's death, there's still money left in the trust. The property still belongs to the trustees, and they are able to wind up Bob's share of the trust and give the value of those assets to Alice and Tom. And what about Alice? Well, she's aware that her business is in jeopardy. She was aware of the time she had to take off time away from her business before her parents died. So she asked the trustees for funds to prop up her business. The trustees take advice, but they decide actually investing in Alice's business is too risky, so they don't put the money into her business. Unfortunately, she still files for bankruptcy and still loses the business and indeed her house in order to settle the business debts. But all the money held in the trust are not taken into account in her bankruptcy proceedings because they don't belong to her. So the trustees lend Alice some money from the trust. She starts a new business, which fortunately flourishes. Alice does very well in her own right from the business and decides to repay the loan to the trust. Because she's done very well in her own right, she then decides not to receive her share of the trust fund. She says to the trustees, look, I'm doing okay. I don't want an inheritance tax liability in my estate. Instead, could you give that trust fund to my own children? The trustees are perfectly able to do that and pass the money down to the next generation without any inheritance tax issue in Alice's estate. So all told, a very happy result simply by making sure there were well-worded, sensible wills in place. My best bit of advice for you when it comes to thinking about a will, particularly where you've got a disabled child involved, is be prepared. Good old Baden-Powell, master of the Scouts from the 1900s, very, very sensible advice there. As I say, this presentation will be shared later. There's a glossary of some of the terms I've mentioned throughout the course of this presentation. I will also say there is the Facebook page, the Parent Carer Forum, that I'd encourage you to log into, and also on our main website, owenmitchell.com, we've got a list of various webinars, and please do feel free to click on the link that's in the Q&A session to provide your feedback. If that link's not up now, then it should be shown fairly soon in the Q&A section. I very much hope that's answered the various questions that you may have had when coming in to this presentation. We have about 10 minutes left now, and Louisa and I would be very happy to answer any additional questions you might have. Louisa, I think you were about to say something.
Hi everybody. Thank you so much everybody for we've got about 17 questions that have come through as Stuart's been talking, so thanks very much for that, and thank you everybody for the questions that have come through prior to the session. I've been keeping a track of those, and I think Stuart, you've answered most of those questions that have come through before the session. So we've only got 10 minutes, so I'm going to whiz through the questions that have come through while Stuart's been speaking. Some of them have been answered, but we'll go through all of them and answer them as best that we can. So the first one is, how is mental capacity judged? So at the start, Stuart talked about a deputyship and clients and and people who lack capacity may need to have a deputy in place. That's probably a question for me that I can answer. Mental capacity is assessed by a medical practitioner. So often a GP will be able to be approached and asked to assess capacity for a client. Sometimes it requires the input of a specialist psychiatrist or a neuropsychologist, but once a medical expert has given that assessment, that is how capacity is assessed, and then depending on the result, you either go down the deputyship route or a different route. Okay, the next question for Stewart probably is, do the executors of a will have to be the same people as a will trustee? I think you've touched on that, Stewart, but I don't know if you want to add anything else.
Sure, yes, be happy to. In short, no, you don't have to have the same people acting as executors as are trustees. Generally speaking, people will appoint the same individuals as executors and trustees for convenience more than anything else, but it's perfectly possible to, say, have a friend or family member act as executor to gather in the estate, to get the grant of probate, and then hand over the estate funds, which then form the trust, to a family member or to a professional trustee, whoever you decide to appoint in your will. The important thing is they must be named in the will. Although trustees can be changed after you die, but that's the decision by the trustees at the time. Hopefully that's answered that. Back to you, Louisa.
Great, thank you. Thanks, Stewart. Okay, we've got a few questions about ages. So is there an age limit in terms of if you're leaving money to your will to a child and either the direct inheritance of that money, can you put an age limit in your will, and can a trust be set up for people that are over the age of 18?
Brilliant, thanks, Louisa. Hopefully, as you were seen from the case study, yes, it is absolutely possible to have a trust set up for children over the age of 18. So under the discretionary trust structure that I gave in that example, it's entirely up to the trustees to decide when, if at all, to give those trust assets to the beneficiaries. You could go a different way and in the will say that you have a life interest, that's the right for income to go to a beneficiary, but when they hit age 25 or when they hit age 30, the trust money must be given to them. The difference there is that the will is binding. The trustees must follow the terms of that trust, and when the child hits that requisite age as specified in the will, the trust fund would have to be handed over. The disadvantage about that is it might not address future problems if, say, the child is declared bankrupt at age 25 or something like that. My general advice is flexibility is a much better way to go. Thank you. Louisa.
Thanks, Stewart. Okay, next question. How many trustees are needed? And to link in with that, one of the other questions is, can you change trustees and guardians and executors if you want to through the lifetime of the trust?
Sure. Yes, so the question about how many trustees should have, I mean, it's a minimum of 2 and ideally a maximum of 4. Technically you can have more, but if the trust owns property, only 4 names will be registered on the land registry title deeds, and therefore we say to people a maximum of 4 trustees, has to be a minimum of 2. In terms of changing executors, yes, during your lifetime, you can change your will as often as you like to change who you want to appoint as executors. An executor's role does not come into effect until you die, so it is not as if you are bound by your decision if you appoint someone you later change your mind as to be your executor. When it comes to trustees as well, during your lifetime, under your will, yes, you can change whoever you've chosen to appoint as trustees in your will. Again, their role doesn't come into effect until the executors give them the money. After your death, or during the lifetime of the trust, when it comes into existence, in terms of changing trustees, then it's up to the current trustees of the trust. So if one of them wants to retire, another trustee can step up in their place. One of the advantages about having a professional trustee, I've mentioned our trust corporation, Owen Mitchell Trustees Limited, is that you've got continuity there. The trustees will continue. A trust corporation can't die, it can't lose mental capacity. So it might be a consideration to have either a professional acting on their own, or a professional organisation acting on their own, or in conjunction with a family trustee as well. Hopefully that answers that question.
Thanks, Stewart. To link in with that, we've got about 4 or 5 questions actually asking, so you better answer this. Asking what happens when a trustee dies. So, for example, if a husband and wife have set themselves up as trustees, what happens if one of them dies? Does there need to be a minimum of 2? And how is the second trustee chosen if one passes away?
Sure. Sure. Yes, a very good question, a very common question there. So as a trust doesn't fail for want of a trustee. Basically, trustees, if you have more than one trustee, the sole surviving trustee has the job of appointing new trustees. When the last trustee dies, it is their executors who have the job of appointing new trustees. So this is one of the reasons I suggest having a professional organisation involved, because it can't die, it always continues, and trustees can be appointed to act alongside it. Otherwise, if you get down to the stage where you've only got one trustee left and they die, then it's whatever their will says about who their executors are, who will get to decide who are the trustees of your trust. Just drawing that out a bit further as well, as if trustees lose their mental capacity, what happens there? And that can be an absolute minefield. A trustee who loses mental capacity can be replaced by the other trustees of the trust, provided the trustee who's lost capacity is not also a beneficiary. If they're a trustee and a beneficiary of the will, then the court needs to get involved in order to replace them or to remove them as a trustee. If the sole surviving trustee loses capacity, then again you're probably going to need involvement of the court in order to replace that trustee. So I think the very important thing is choosing your trustees is absolutely vital. A lot of thought needs to be given to that. Their age, their mental capacity, obviously, but also their practical personal capacity. Do they have time to run the trust, to manage it for many, many years into the future, running those funds for a child's benefit? Hopefully that answers that question as well.
Lovely.
Or those questions.
Thanks, Stewart. We've got a couple of minutes left. I'm going to squeeze in one more question, which is how often should a will and trust be reviewed and updated?
Yeah, again, a question I get a lot. There's no sort of rule of thumb really, although I do say make sure you dust off your will at least every 5 years to make sure you still know what it says, still can remind yourself how it works. Certainly whenever there is any major life event, so a birth of a new child, make sure they are incorporated in your will. A marriage, bear in mind marriage ironically revokes a will. So if you have a will and you subsequently get married, your will is revoked on the date of the marriage. Divorce does not revoke will, funnily enough. Instead, the divorcing spouse is treated as having died on the date of the divorce, which is something that some people might think an entertaining thought, that the next spouse has been treated as dying. But it's very, very important to dust the will off, look at it, make sure it still does what you need it to. Moving house, coming into wealth, losing wealth, all those major life events are a good time to have another look at your will. But get it out of the cupboard regularly and just remind yourself of your terms. Make sure you know what it says. Okay.
Lovely, thanks, Stewart. I think that covers most of the questions. We've also had quite a few questions about the cost of advice, whether a step registered solicitor is the most appropriate person to provide advice, and what Owen Mitchell charged and how we can help. All of that information can be circulated separately after the event. There will be a recording, as Stewart has said as well, which I understand will be circulated after the event. So I think that deals with all the questions, Stewart. I don't think there's anything else. So I'll pass back to you to finish off.
Yes, thank you, Louisa, and thank you everyone for all your questions. Really appreciate it. I hope we've had time to come on and answer all your pressing questions. So if you do have anything else that you specifically would like answered, do feel free to get in contact with Louisa and myself. Our contact details are there on the screen. And once again, please do take some time just to fill out the feedback questionnaire. Your thoughts and views are very important to us. But otherwise, thank you very much for joining us, and I hope you found it very useful. Thank you.